Hi, good morning. My name is Scott Green. I'm the managing partner for the Green Law Group. We're a law firm essentially built for construction. We currently have 8 lawyers and things are busy. Looks like we're going to be adding folks before the end of the year. So today, this is all about arbitration. I know that's not a real exciting topic, but it's important nonetheless. So I'm going to hit some highlights. We've got some material that we're going to be sharing. I'll probably loop back to the actual material after I cover the highlights in my notes, just to make sure I haven't missed anything. But first, I want to acknowledge our sponsors. Let me see, is this going to move for me? Okay. So these are folks that, have helped us and helped people in the construction industry, particularly in our area in Ventura. So go ahead and check them out. Here's my disclaimer that this is all about general information. It is not specific legal advice. For legal advice, consult your lawyer. A little bit about us and what we do. And like I said, we do everything that contractors need, business-wise. This is our fine-looking group of attorneys. Arbitration agreements. So the first thing to know is that how they arise. The arbitration agreements are created in contracts. So if you enter into a contract to build something and you're using one of the common contract templates, like something from the American Arbitration Association or from the Association of General Contractors or consensus doc form or several others, there's probably an arbitration agreement in the contract. And it may require separate initialing and approval, and it may not. The reason that these arbitration agreements are so common is because the court system is expensive, unpredictable, frustrating, and takes too long. So let's say that you're, as a contractor, the most likely dispute you're going to have on a construction project is you're not going to get paid. And let's just say you get to the end of the job and you're owed a couple $100,000 and you didn't do anything wrong, but you're not getting paid. Well, if you did a preliminary notice and or set yourself up so that you recorded a valid mechanics lien, you may have to file suit to preserve that lien and then put the suit on hold and go to arbitration if your contract provides for arbitration. Now, why would you want to do that? It sounds like an extra layer of complication, which it is, but you can get to arbitration, get an outcome in arbitration in, let's say, 6 to 9 months. Whereas if you're going to court, it's more likely to be 12 to 18 months. And the big frustration with the court system is running into continuances. For instance, during the pandemic, boy, the court slowed down to a crawl. Things that should have been completed and gone to trial within 12 months are now a couple of years down the road, because when things got backlogged, the courts had to focus on criminal matters and civil matters got put off. So in arbitration, why is that different? It's because it's private party and it's not the court system. The arbitrators are getting paid by the hour and they're pretty pricey. But when you get a date for arbitration, you're not really competing with other matters that might be on the same calendar like you are in court. So when you get down for a trial date in court, you might hear from the judge that there just aren't any courtrooms available because they've got too many other matters going on, particularly criminal matters. That doesn't happen in arbitration. So if you have a date for an arbitration, you can rely on it. And that's important for a number of reasons, but in particular, think about the frustration and the cost and expense of preparing for a trial with you and your lawyer and your witnesses and all your documents, go on down to the courthouse, get settled in, only to hear that you need to come back in 30 days or 2 months. So you just spent all that money to get down there for trial, to get ready, and now you have to put it off. And in a couple of months down the road, your lawyer's going to have to prep somewhat all over again. So you're going to pay for that. And then when you go down for the second time, still no guarantee that your matter's going to go forward. So that's a problem. The other problem with juries is juries. There are no juries in arbitration unless you specifically draft an arbitration agreement that provides for a private jury. Those are kind of rare. You can do that. But juries add expense. And so there's normally not a reason to want to have a jury in a civil dispute. And but the law, however, gives either party the right to request a jury. So let's say you're a contractor and you have a dispute with a homeowner, and your contract does not have an arbitration provision, and there's enough money involved that it looks like it might go all the way through to trial, and the homeowner decides they want to have a jury. Why would the homeowner want to have a jury? Well, it's because contractors and other professionals, I would include lawyers, don't necessarily have a great reputation with ordinary folks who might be sitting on that jury. So if you have to go to trial and face a jury, you're going to have 12 folks who are going to walk in that courtroom and make a determination on your case, and they might have bad experiences dealing with contractors in the past, and they might feel like, okay, they might prejudge the situation and think that it was similar to something that happened to them, and now is their opportunity to, extract some vengeance. So juries are not only more expensive, but they're a little less predictable, and that's a risk when you're a contractor and you're trying to get paid for the work that you performed. So if you go to arbitration, if you have a contract agreement that provides for arbitration, you're not going to have that. You're not going to have juries. You won't have the expense of preparing for juries. So things will go faster. You will, however, have to pay an arbitration service. So the largest arbitration service is the American Arbitration Association, and they're pricey. They've been around for probably, 100+ years, and they are the selected service in most of the large contract documents. So they hold pretty tight on their charges because they're kind of locked in. They kind of have the franchise, let's say, and they charge for it. Now, if you have the opportunity to negotiate your arbitration agreement up front, you might want to give yourself some flexibility to provide for alternative arbitration services. There are several, and some of those charge less money than the American Arbitration Association. But in all likelihood, that's where you're going to find yourself, though, if if you have a dispute and you have an arbitration agreement in your contract. So what else do you have to pay for? You have to pay for the arbitrator. And the arbitrator is generally selected by agreement between the contesting parties. And if they can't agree on a person, then the arbitration service, like the American Arbitration Association, will give you what we call a strike list. So let's say they'll circulate a list of half a dozen arbitrators, and each side will be able to strike 3 of them. and submit their strikes, and then the arbitration service will pick from the remaining available arbitrators who were not stricken from the list. But then you got to pay that arbitrator, and arbitrators are expensive, $300, $400, $500, $600 to $1,000 an hour, depending upon who it is and how sophisticated the project is and dispute is. So that's an expense. But when you're talking about comparing arbitration and the expense of arbitration with the expense of going to court and litigating, when you're in court, you also are likely to have much more discovery, which means that's the opportunity for both sides to obtain documents from each other, to take depositions from each other, to submit written questions to each other. And in that discovery process, that can get quite expensive in and of itself. So a typical deposition usually runs like $3,500 to $5,500 a day, including the cost of the court reporter, getting copies of everything, preparing for the deposition and actually handling it. So if you're in arbitration, those things are generally not provided for in typical arbitration agreements. In other words, there is no guaranteed right to take depositions. Now, the parties might decide that they want to agree to a limited number of depositions. That does happen. But if there is no agreement, it's up to the arbitrator and the rules governing the arbitration as to whether or not one party could compel depositions. So if you're a contractor, though, and you're owed money, likely you already have all of the evidence you need to put on your case. And you have your contract, you have your invoices, you have people that would testify about the work that you perform, so you don't need a lot of discovery. The property owner may be in somewhat of a different position. They may, want to drill down into, some of the documentation. They may have a little more interest in discovery, but most contractors can prepare their cases to go forward on a breach of contract claim where they're owed money without a lot of discovery. So that's a reason to go into arbitration as opposed to litigation. Avoid the general expense of discovery, particularly if the party on the other side's got deeper pockets. If you're up against somebody with real deep pockets and they can afford to, in litigation, take, a bunch of depositions and may force you to spend a lot of money on your attorney, well, that might, push you into a financial, distress situation where you end up resolving or settling your case for significantly less because you just can't afford to fight. That's a real thing. In fact, I would say that it's probably the most motivating factor is to explain why most cases don't go to trial or even settle before arbitration, because of the expense. People get tired of the expense. And so you might start out all gung-ho and think, oh, this is a matter of principle and I want to get every nickel. And then 6 months in, after you've been writing checks every month to pay your attorneys and pay for experts and pay other fees, you might be a little more flexible in terms of what you're willing to settle for. So that's a factor to keep in mind. The other thing about arbitration is, generally speaking, it is binding, which means there's no right to appeal, which can also be a significant cost savings. There's a risk naturally as well. The risk being that your arbitrator might make a mistake of law, and then you're going to be stuck with it. That could happen. If a judge makes a mistake, you can take that up on appeal and have the appellate court, weigh in and possibly reverse the judge. But that's also a pretty expensive process. So in the typical construction dispute, usually isn't the kind of money involved that would make taking a case up on appeal viable option, because appeals are also expensive, and there's no guarantee that the appellate court is going to rule in your favor. So if you have an arbitration agreement, you don't have to worry about appeals. You go in, put on your best case, and win or lose, that's the outcome. It's done. Something else about arbitrations is, you don't have to have an attorney represent you in an arbitration. I would strongly recommend it. But in arbitration, since it's a private party agreement, and it's not subject to a lot of the rules that the litigated matters are subject to, you could represent yourself and even your corporation, if you have a corporation, in an arbitration. But it's like I could also build my own house. It'd probably turn out to be a complete disaster, but theoretically I could do that. You would want to think the same way about handling your own arbitration. It's like, just because you could do it doesn't mean that you should. But sometimes, it's a relatively simple matter. Financially speaking, it might not be viable to pay attorney's fees to handle an arbitration. So you have that option. Whereas if you're in litigation and your business is incorporated, you must have a lawyer represent the corporation. So that's something to keep in mind. Also, in terms of payment of the arbitration fees, that is also a matter of contract. So you want to read those contracts carefully, and in the arbitration provision, figure out, well, in the event we have to go to arbitration, what's the split going to be on paying for the arbitration? Is each party going to pay their fair share, 50-50? Or is the agreement written in such a way that the party bringing the arbitration needs to pay initially? You can take a look at that, and take that into account. Yeah, another thing about arbitration, which I think is significant to know, is it's not public. So, there are some benefits there. You may not want to, have a dispute litigated in public where you're filing things with the court and anybody can go down and get a copy of whatever it is you filed and use it, take a look at it, publicize it. Let's say that you're working on a very high-end residential custom home, and there are allegations about construction defects on that property. The property owner certainly might want to keep that, somewhat under the radar and not have a public document filed with the court system that alleges that this very expensive custom property is got defective construction. There may be other reasons why that has to be disclosed in the event the property is sold, but keeping it out of the public domain by a private party, private arbitration versus a public trial, is a consideration. Now, mediation is something that often runs tandem with arbitration agreements. And mediation, the difference between mediation and arbitration is mediation is not binding. So if you have the opportunity to have a dispute submitted to mediation before it goes to arbitration, the benefit there is with a good mediator, there's a high degree, high possibility that the mediator will resolve the case. And a good mediator is going to resolve the case by pointing out the weaknesses in the claims for each side, getting them to see that it may not turn out the way that they like, and that having a certain outcome, before spending money on arbitration and getting it resolved in mediation might be beneficial. So a lot of arbitration agreements will have a condition that the parties mediate before they go to arbitration. That's not a bad thing. It might be an early way to resolve the dispute. So let's see if I've covered everything on this first screen here. I've not talked about employment agreements yet. So let's jump into that for a minute. If you're a business owner and you have employees, you also don't want to find yourself in front of a jury if you end up in a dispute with one of your employees. Again, who's likely to be on that jury? It's not likely to be a lot of other employers. It's more likely to be folks who are employees, and they may have biases against employers. So how do you avoid putting yourself in a situation where you have to go through a jury trial when you have a dispute with an employee? You can have an arbitration agreement with your employees. And there are certain rules that apply to arbitration agreements with employees. You can't force existing employees to sign an arbitration agreement, so you have to have something called an opt-out provision if you offer it. But when you hire somebody new, you can make a condition of the employment offer, or you can condition the employment offer on their agreement to enter into an arbitration agreement. And so I recommend that because, again, it's the unpredictability of juries, it's the expense of juries, and it's the time it takes to go through a jury trial, and it's the public nature of a jury trial that, well, none of those things are good for employers. Now, if an employee is going to sign an arbitration agreement, they're giving up their right to all of those things. And in exchange, what California requires is that the employer is going to pay all of the arbitration expenses so that there's a benefit to the employee to sign off and agree to arbitration because it won't cost them anything. Yeah, that's also a potential downside for an employer because the employees figure that out and it's like, well, if they have a dispute, they can't work it out with you. There's very little downside for the employee to say, well, let's go arbitrate in accordance with our agreement. And then what happens right off the bat is the employer has to pay the arbitration fees. The company that's providing the conference room and the arbitrators and all that, they can add up, they can get kind of pricey. So you might be in a position to offer an early settlement even on a case you think is defensible because of the expenses to arbitrate. But from a business point of view, that might be a preferential thing to do in any event. Because even if you go through arbitration or trial and you win, you're going to incur attorney's fees, which can be substantial. If you lose, in most employment disputes, the employee has the right to recover their attorney's fees. That right does not extend to the employer. This was a case where the state of California is trying to balance what it sees as the likely deep pocket party, the employer, versus the employee, and giving the employee the incentive or the additional benefit of being able to recover their fees, attorney's fees and costs, if they prevail against an employer. If the employer wins, the employer doesn't get to pursue the recovery of their attorney's fees from the employee. So that's kind of a balancing thing, but something to keep in mind. And even with that, I would still recommend arbitration agreements. Now, there's a big exception to those arbitration agreements that they do not apply to something called Paga claims. A Paga claim is a private attorney general action that is provided in California, where one employee can essentially bring something like a class action representing a representative action on behalf of other employees against the employer for a certain limited number of violations of law. So let's say, for instance, that there's the employer is not completely complying with the requirements for payroll and giving all of the required information on the pay stub. It might be a relatively minor thing for one employee and certainly not make it worthwhile to, bring a claim. But if the employer has 1,000 employees and has one minor issue, bringing a Paga claim on behalf of 1,000 employees might in fact be a very viable thing for the complaining employees. So that's a little bit about Paga. So even though you cannot control Paga with arbitration agreements, there's a whole bunch of things that you can control. Claims for employment discrimination or disability discrimination, all those things can be relegated to arbitration as opposed to litigation. So let's see what else we have. All right, so I've mentioned that you can't have arbitration unless it's in a contract or a standalone agreement, and that you can have an agreement that also includes mediation. So this is just some common language that you might see in a contract for that. Here's a little more of that. Sample terms and conditions. Now, attorney's fees, outside of the context of a dispute between an employee and an employer, I strongly recommend that you have a provision in your contract, whether it's designed for arbitration or litigation, that the prevailing party is entitled to recover their attorney's fees. The reason for that is, the attorney's fees can really add up. So let's say you're owed $250,000 and you're the contractor and you can prove up your case and the owner really doesn't have any good defenses, but the contract doesn't provide for the recovery of attorney's fees in the event you win. And then you ask your lawyer, well, how much could it cost me in terms of attorney's fees, court fees, expert fees to pursue my $250,000 claim if the owner, who has deep pockets and can afford it, decides to take this to the mat and go all the way through trial or arbitration? The lawyer might say, well, it could cost you your $250,000 or more. So if you can't get that back if you win, then you're in a disadvantaged position and you may have to negotiate a steep discount just by virtue of the fact that, otherwise you're going to have to incur attorney fee expenses that you can't get back even if you win. So you want to look at your contracts and make sure that they do provide for the recovery of attorney's fees in the event of a dispute. Okay. Paga claims we already touched on. Bingo. I think we've come to the end here of everything you wanted to know about arbitration, but were afraid to ask. And if there are other things that pop up, if you're looking at this on YouTube or someplace else, you might find it on the big old web. There's my email address and phone number, and you can certainly follow up and ask some more questions, and I'll be happy to help. Take care. Hope you found this interesting or at least informative.